She started from nothing and really built her way up. There was the glam, there was the beauty, there were the cars, the houses.
Srimati Indrani Mukherjee, the CEO of INX Media.
What has happened to Sheena?
Breaking news just coming in. Media tycoon Indrani Mukherjee has been arrested by the Mumbai police on charges of murdering her sister almost 3 years ago.
It's a case that has confused, fascinated, and shocked us all.
What is the precise motive that could have led Indrani to kill Sheena in cold-blooded murder?
Go on then. Ask me whatever you need to.
Each and every character of this particular story is extremely unique. Everybody has got their individual agendas.
Sheena, who till yesterday we thought was Indrani's sister, has turned out to be her daughter.
स्टार्टिंग में अगर एक झूठ ब्रॉडकास्ट हो जाता है, सबको ये जानना जरूरी है कि पहला सच है क्या.
Peter's son, Indrani's daughter are involved.
The son of the current husband is seeing the daughter of Indrani's previous marriage.
The family themselves, they're leaking a story a minute.
Do I believe someone within the family knows what's happened to Sheena? Absolutely.
Did you murder your daughter, Sheena?
What a stupid question.
That yesterday, at the request of the people, the court issued an order barring Mr. Rand from being in attendance at the trial at any time when the jury is present. And I am here today to ask you to review and reconsider that order and hopefully enter a new and different order. I think there are two grounds that support that motion. First, I don't think Mr. Rand should properly be considered a witness in the trial. He's not designated as part of the state's case in chief. I don't believe he's been thought of as a rebuttal witness. And at best, he could, under a certain chain of circumstances, which is probably best described as speculation and conjecture, may possibly be relevant to an issue of impeachment. We don't think under those circumstances he should be considered a witness today. I would also urge the court to reconsider its prior order as well with respect to whether or not Mr. Rand is covered by the state's privilege law. And I would like perhaps an opportunity to brief that on a written basis should that issue arise in the future. And I would cite to the court the case of People versus Von Villis, which is in fact mentioned in today's Daily Journal article, which indicates a Second District Court of Appeal ruling holding that the state privilege shield law applies to freelance journalists under a book contract and not specifically the narrowly defined category or class of individuals listed in the preamble to the statute. My second reason to ask that the court reconsider its order is that under Evidence Code Section 770, an exclusionary order is designed to prevent a potential witness from hearing and perhaps being influenced by the testimony of other witnesses. Under the unique circumstances of this case, where the trial is being broadcast nationwide on TV, and where Mr. Rand is free, I believe, to go down the hall to the media center and listen to the trial, an exclusionary order simply can't fulfill the one purpose which the statute says it is designed to do. And given the fact that it can't isolate him from the testimony he would hear, and under the circumstances too where Mr. Rand is a journalist writing a book, it would seriously impede his efforts to prepare and properly research for that book. We believe that he should be allowed to be present at all stages of the trial.
All right, before I hear a response from any of the parties, let me just ask, you referred to the Von Villis case. Is that a case that's reported today in the Daily Journal, or is it an article? Or I don't
It's an article about the court's ruling. I must confess that I wasn't able to get to Westlaw last night, so I haven't read the whole opinion, but it refers to a decision by the Court of Appeal, which the Supreme Court refused to hear. The decision let stand and it applied the privilege to a freelance journalist by the name of Jan Golub, who had been ordered to produce taped interviews of a key prosecution witness in a criminal trial. And I'll be happy to provide a copy of that to the court this afternoon.
Well, I'm aware that there is a case called Von Villis. I was unaware that it deals with that subject matter, and it was never brought to my attention at the time Mr. Rand's issue was before the court. Certainly, I'll look at that case if it deals on that subject. I'd be very interested in that.
I'll provide the copy.
All you have to do is give me the citation. I'm sure it's in the advance sheets. It's a case that was decided several months ago, but the significant issue in that case had to deal with the situation of two juries, which is really the subject of concern of this court in regards to Mr. Rand and his presence in the courtroom. And let me hear from counsel and any responses you have to the factual presentation made today on behalf of Mr. Rand or any legal positions you take.
Who would you like to hear from first?
Anybody.
Okay. Your Honor, Mr. Rand has crossed the line from being a journalist to a witness in this case, and he did so of his own free will. On Monday night, as the court knows, Mr. Rand divulged and published portions of an interview, which then made him a witness for purposes of impeachment of one of the prosecution witnesses. That witness is still on call. I believe the defense still intends to call him, at which point Mr. Rand would at least have to authenticate the conversation on the tape. We know that Mr. Rand has talked to, by his own admission, over 300 people involved in this case. I know he's talked to Mr. Stevens. I don't know whether or not the defense will seek to use anything Mr. Rand gleaned from Mr. Stevens to impeach him at a later date. Deputy Honings, one of the bailiffs in this courtroom, indicated to me that Mr. Rand, he saw Mr. Rand at the 3 p.m. break speaking with the defense attorneys in this case. Mr. Rand told me 2 or 3 years ago that he had interviewed Lyle Menendez, whereupon I immediately called Ms. Lansing and told her of that. Mr. Rand told Mr. Kuriyama that he'd interviewed both defendants in this case. And Mr. Rand also told Mr. Kuriyama that he has spoken to 2 of the 3 women involved in the allegations against Dr. Oziel, and that they gave information to Mr. Rand which is inconsistent with the allegations contained in the accusation. Therefore, I think that by the virtue of the fact that he has injected himself into this case as a witness, he cannot now choose which he wants to be. He's either a journalist who is going to take an impartial role in the case and report, or he is a witness in the case, which is, I think, what he decided to become on Monday night. And for that reason, we would ask that he be excluded, and furthermore, instructed not to view the testimony in the case in the same way that the court instructs witnesses not to discuss their testimony with other witnesses.
All right. Did anyone else wish to be heard?
It's our position, Your Honor, that we have no objection to Mr. Rand remaining in the courtroom. We agree with counsel for his that would serve no purpose, since he's free to walk down the hallway and watch.
Yeah, why don't you turn your mics on so that your brilliant remarks can be heard by everybody here.
I think it was on, Your Honor.
Somebody was complaining that they weren't on. Or maybe it was complaining about the quality of the remarks. I don't know.
That may be probably more likely. But in any event, Your Honor, I think it's nothing more than punishment inflicted upon Mr. Rand for what the prosecution perceives to be, in her view, bad journalism. And I don't think it serves any purpose to exclude him as opposed to any other journalist sitting in this courtroom who has interviewed witnesses. If that were the rule, the defense could clear out the room by simply serving subpoenas on every journalist and magazine writer who's sitting in this room who has interviewed witnesses, and I can assure the court there are many.
All right. Let me ask the defense whether or not, and this is what was asked of you yesterday and earlier this week. The question is whether or not you intend to call Mr. Rand as a witness.
Your Honor, the only circumstances under which Mr. Rand would be called as a witness would be if Mr. Goudreau denied that his voice was on the tape, which we have received, and he's already stated that it is his voice. So we don't, at this time, intend to call Mr. Rand as a witness. The only purpose would be to authenticate the tape. And I think Mr. Goudreau has already done that with reference to the portion of the tape played on the broadcast that the court heard.
And do the people intend to call Mr. Rand as a witness, not speculating about some other events that might occur, but just in regards to Mr. Goudreau.
Yes, Your Honor.
And could you tell me a little bit about that?
Yes, as the court may recall, when Mr. Rand was on the stand on Tuesday, I asked him questions about information which he had imparted.
Is your mic on?
Yes, but I'm sitting far away from it. Mr. Rand, I asked him, if the court recalls, about information about a bath that he imparted to Mr. Stevens.
A what?
A bath that the defendants had taken with their father. He told it to Mr. Stevens. I believe Mr. Stevens testified that he discussed it with Mr. Goudreau. And I intend to question Mr. Rand about that series of events as I did, as well as question his motivation in this case, and his bias and interest.
And you feel that that will occur at some time during the defense case if the defense seeks to introduce the tape recording?
Well, I would,
Mr. Goudreau?
Unless they call, if the defense calls Mr. Rand to authenticate the tape, then I would cross-examine him. If the defense does not call him, I would call Mr. Rand in rebuttal.
All right.
And I have served him with a subpoena. That was for Tuesday, but he has been served with a subpoena.
Okay. All right. And that subpoena relates only to Mr. Goudreau and only in relationship to that one audio tape. Is that correct?
That's correct.
Okay. All right. Did counsel for Mr. Rand wish to be heard further on the remarks that we've heard?
No, I'm still not clear to the prosecution's position as to the relevancy of any of that testimony. It seems to me that Mr. Rand is not a proper witness in this proceeding, and that, in fact, he is being punished by the people for producing a videotape, the contents of which they do not like at this point. And I think that his bias and interest and his methods as a journalist simply are not an issue that's material to the proceedings now before the court. And in the event that something should develop where Mr. Rand would be called to testify with respect to a conversation that he may or may not have had with Mr. Stevens, it seems to me that the court should defer any blanket exclusionary order until such time as Mr. Stevens is called to the stand. The witness who has testified, as I understand it, has authenticated his voice on the tape, so that's really not a matter in issue anymore. And I don't believe that Mr. Rand would be called to authenticate the witness's voice.
All right. Well, let me discuss a few things here. Number one, the issue that concerns the court is not so much Mr. Rand as a potential witness being in the courtroom and hearing what other witnesses will say. That, as you indicate, is not a significant concern or issue, since the trial is a public trial and what occurs in this courtroom is disseminated to the outside world, and Mr. Rand has access to that. The concern the court has is the fact that we have two juries and a very small courtroom, and that potential witnesses would be sitting in close proximity to the jurors, one jury panel being in the audience, and also potential witnesses being in close proximity to the jurors as they come into the courtroom, as they leave the courtroom, and contact with them in the hallways and things of that sort. And if a witness is in the courtroom, the potential of contact with the jury panels is much greater than if the witness is not in the courtroom. The court has made exception for members of the defendant's family, and there's a designated space for them. I really have no knowledge as to whether any of those individuals who have been in the courtroom, members of the defendant's family, will be witnesses in this case, and there has been no objection by the prosecution to their presence. That is really the court's concern, that if Mr. Rand does become a witness, his close proximity to the jury will put his testimony in a different light than any other witness who comes into court, that the jury will have been exposed to him for a period of months and view him differently than some other witness who walks in the door and the jury sees him for the first, or her for the first time, and evaluates that person based only on what happens while the witness is testifying, doesn't have a chance to see the lawyers talking to the witness during the trial for extended periods of time in the hallway, and doesn't see the witness talking to other witnesses while the case is pending, things of that sort, which apparently Mr. Rand engages in, activities such as that. And there's nothing wrong with that activity. That's part of his role as a journalist, as he regards himself, and that's fine. There's nothing wrong with that. But that is my concern. That's one issue. Another issue is a separate one, and I assume that has to do with Mr. Rand's request to have an assigned seat in this courtroom. As you're aware, there is a very limited seating space. This court has had to allocate seats among competing media interests here, and Mr. Rand early on expressed interest in having a seat, and the court accommodated that request, even though he is not, at this stage of the proceedings, publishing material that is broadly disseminated during the course of the trial, as are other members of the media. We have other people from the print media here and people from the electronic media who are assigned seats. And we also, and I have accommodated other people in a situation similar to Mr. Rand who have requested assigned seats in the courtroom. There are lots of other people outside of the courtroom who are members of the media who also want seats in the courtroom and want assigned seats and want to have a regular seat each day in the courtroom. And those other people are not witnesses in this case and will not, as far as I know, ever be a witness. And the court has to put that into the equation, deciding whether or not, separate and apart from a generalized exclusionary rule, whether or not Mr. Rand should be given a specific seat in this courtroom on a daily basis versus his access to the media room, which would give him a means of viewing the proceedings and watching the proceedings as they go on. So that's a separate issue altogether. So the first issue is whether Mr. Rand is a potential witness and as such would come in close contact with the jurors and therefore create a potential problem if and when he does testify. So those are my concerns.
Might we be heard
on what?
On those two issues?
I don't see how you could be heard on the second issue. That's certainly not within your
I have some information.
discretion.
I have some information to report on the second issue.
Okay.
There are other journalists who have assigned seats in this courtroom who are merely writing books.
I know that. I just said that.
And at least one of them extensively interviewed witnesses and revealed his sources to the police department. Acted, in fact, as a source of information for the police department and may himself at some point, if it ever became relevant, be a witness.
I don't know who that is. Who's that?
We're not seeking to exclude that person because we feel that the journalists, as compared to other witnesses, have, and all the journalists that we have seen have stayed away from the jury. And the jury has been admonished to stay away from them, and they seem to be far more scrupulous and careful than the other hangers-on and witnesses who show up. I mean, our jury has seen Donovan Boudreaux, Glenn Stevens, and Mr. Lankowski sitting out in the hallway talking to the prosecutors and police officers for 2 or 3 days at a time. But
that's a limited thing. That doesn't happen throughout a 4 or 5 month trial every day.
I haven't seen any of the journalists talking near the jurors or to, and I'm not just saying Mr. Rand, I haven't seen any of them violating rules of this court.
I haven't said they have. I'm very comfortable with the fact that they're behaving properly and appropriately, and I have no criticism of them. I welcome them in the courtroom, and if we had more seats, we'd have more of them here. But I have a limited number of seats, and I have to allocate those seats, and really, the defense or the prosecution has no standing to speak on that subject. So let's get on to the first subject.
I just wanted you to know factually that there were other people in the same position as Mr. Rand. As to the first thing, we're concerned with the notion that any witness, although there's been no exclusion order because
there has been no motion to exclude witnesses.
Exactly, by either side, because it would be so futile. For the purpose of exclusion, given the electronic dissemination of the trial, the purpose of the statute cannot be met with an exclusion order.
Well, even if it wasn't electronically broadcast or televised, you still have the print media putting out whatever is going on in the courtroom.
But I think our concern is that the court seems to be fashioning a new rule for exclusion, which is familiarity with the case of the person as somehow enhancing or diminishing the credibility in the eyes of the jury. And I don't think there's any support, any logical or psychological support for that concern. I certainly agree with the court that if witnesses are chumming about in front of the jury, that would be a problem. But their mere presence, because there are people that we may want to have present on several days before they testify for a variety of reasons, and we don't think their mere presence sitting in the audience passively enhances or decreases their credibility.
I'm not talking about the few days. I'm talking about throughout the whole trial. And Mr. Rand and others become fixtures, and people become familiar seeing them every day, just as they see the back of your head every day. So they, okay, so that's different than just coming in and staying for a couple of days. All right, yes.
It's different in terms of amount of time, but I'm not sure that the conclusion that the court seems to be reaching, which is that the juries will somehow draw either a good or a bad impression of Mr. Rand, and thereby either give his testimony more or less weight than they otherwise would, is sound. It seems to me they see a face, they know they've seen him have a cup of coffee somewhere, and they're probably wondering why he's here. But I don't think that knowing the fact that someone's been at the trial for a period of weeks necessarily leads a juror to conclude that he is a good or a bad witness. And it seems to me simply seeing a face doesn't really change the impact that the testimony would otherwise have. With respect to the assigned seat, it seems to me that Mr. Rand obtained that seat originally.
He did what?
He obtained that seat originally for sound and valid reasons. He's a journalist working on the book under contract with Simon & Schuster. I think that he should keep that seat unless he does something egregious. Clearly, we do not claim the right to talk to jurors. I don't think Mr. Rand has done that. He certainly will not in the future. I don't think anyone's even suggested it. Other journalists are here working on similar projects. I believe he should keep that seat, and it seems to me that the only reason this motion is being made now, again, is sort of to get back at him a little bit. It's a payback, and I would urge the court not to join in that and not issue any sort of exclusionary.
Well, obviously, I'm not concerned with or would not want to be involved with in any way a vindictive response to whatever Mr. Rand did. It's quite understandable the general nature of Mr. Rand's response if he felt that he saw something occur in court that constituted, in his mind, perjured testimony, that he felt obligated to respond to that and let counsel know of it so that it could be brought to the attention of the court. And that was certainly an understandable and laudable idea. The manner in which he went about doing it and exposing the information on television is something else. And the position taken that playing a portion of it on television and then playing a larger portion of the same conversation to the defense lawyers and then claiming that there was no waiver of the entire conversation based upon the fact that there was a substantial portion of it played is a separate issue. And one can debate that, and perhaps even with this Von Billis case, if it stands for the proposition you support or propose rather, still the court's ruling might very well have been the correct ruling in regards to that audio tape. I'm not litigating that now. It's already been ruled upon, and if you want to bring it back for further discussion, we can do that. But I certainly don't want to take the position that anything this court does is vindictive towards Mr. Rand or responsive to what you regard as the people's desire to make Mr. Rand pay for whatever he did. That's certainly not what the court wants to do. The court is concerned with the orderly process of the trial and the cumbersome aspect of the two juries, which is much different than the average trial. Yes.
With respect to the potential for Mr. Rand to be a witness in this case, I would like to add a couple things. On July 27th, I spoke to Mr. Rand. He indicated to me that he interviewed both brothers a few months after the murders, that Eric Menendez in particular, he interviewed for over 3 hours, he said in his opinion, Eric Menendez was the best actor in the world because Mr. Rand, after spending all this time with him, had no clue that he was involved in the killings. In addition, Mr. Rand told me that what the women are alleging against Dr. Oziel is outrageous, that he has spoken to the women to the exception of Elon Smith, that he knows that none of the women are patients. And if those witnesses were to testify, I trust that Mr. Rand would see fit to go to the media, as he did on the night of July 26th, and become a witness in those situations as well. So I think there's a high likelihood that he would be a witness on the case.
Well, I'm certainly not ruling on those potential areas of testimony. Obviously, by injecting himself into these proceedings, Mr. Rand has created a situation that might cause the court to deal with further litigation on the subject. That's certainly a possibility. Did you wish to respond?
Well, it seems to me that that really what that statement goes to is the fact that Mr. Rand is doing his job as a journalist, and whether or not the people come up with a theory that would make him a witness, it seems to me is an event that's down the road, and that we can't really decide that today. And I think it depends in large part also on what this new case may say about the privilege issue. And as the court noted earlier, the concern really isn't Mr. Rand's role as a witness, which affects the exclusionary order. It's other concerns. So I don't think that this really affects the issue to be decided today.
All right. Just to say one more thing, there's reference to a limited number of seats here, and there are many other reporters who are requesting an opportunity to be seated here every day, and they don't carry with them the baggage that Mr. Rand brings with him because of these most recent events. And the court has to consider that in allocating those seats, as well as taking into consideration other things that must be considered. I am concerned that there is, although the people say otherwise, there is a rather slim chance that Mr. Rand will be a witness. And I have not listened to that tape recording of the conversation with Mr. Goudreau, and I don't know what exactly is on it that would cause the need for Mr. Rand to be a witness himself rather than just a tape being played, assuming there is efforts to go forward with that testimony of Mr. Goudreau, and I don't know if there will be. What I will do is order that Mr. Rand, at this point, be permitted to stay in the courtroom when the jury is not in the court, and order that at this point the seat that has previously been assigned to him will not be assigned to him, that it will be assigned to someone else if there is another news agency that is interested in a permanent seat and will occupy that seat on a permanent basis.
Your Honor, until we've clarified some of the other issues, would it be possible to have the seat now assigned to Mr. Rand be used by his researcher and assistant reporter?
Well, what I'll have to do is determine what the demand is for these seats. It's my understanding that the Daily Journal has taken over his seat, and whether or not they are really sincere in using it every day, I don't know. I don't know if they're here today or not. They are, okay.
But this is not Mr. Rand's seat. Jerry Ann.
Who are you?
I'm Mary Jane Stevenson.
Yep.
And Jerry Ann
Okay, I'm unaware of that and unaware of whatever the specifics have been in the last week or so of assigning seats. So I'll deal with that. And no, I was not. I thought you had taken over the seat that had been assigned to Mr. Rand. That was how it was presented to me. Okay. As of now, then, if there is a seat available that has not been otherwise allocated, Mr. Rand's assistant may occupy that seat.
Thank you, Your Honor.
And obviously, as I've indicated, Mr. Rand can certainly use the media room and observe the proceedings there.
Yeah, and I take it that if circumstances change, we can revisit this issue.
Yeah, absolutely. This is always subject to change, and it could very well be discussed again.
Thank you very much.
And if you have any briefing you want to present to me on that Von Villas case, I'd certainly like to see it, or any other case that deals with that subject. It's certainly an area that is of interest to the court, and I'd certainly like to see your views.
Absolutely will. Thank you.
Thank you. All right, are we ready to proceed with the hearing?
Yes, Your Honor.
Okay.
Dr. Oziel, present, would you like me to take the stand?
Yes, is he proceeding without his counsel?
Yes, counsel will be here around 10:15 or 10:30.
Okay, would you resume the witness stand, please? All right, would you state your name again for the record?
Dr. L. Jerome Oziel.
All right, we're in the process of going through the statement of, or the transcript of the conversations of October 31st and November the 2nd. And we were on page 14, as I recall.
Your Honor, are we on the last paragraph?
Yes, we had finished with the previous paragraph, and we're on the last paragraph. The full paragraph of page 14 was to be received only as to Lyle Menendez, and then we were discussing the bottom half of that page. And I believe the defense wanted to ask questions of the witness. By the way, for the purpose of the record, the Xerox copy of the statement of Dr. Oziel, which has been used by the court, all counsel, and the witness in these hearings relating to what is and what is not admissible as to one or both defendants. That copy with its bracketed portions will be marked as an exhibit so that the record will contain reference to it. And it'll be marked as Exhibit 62. All right, anybody have any questions of the witness in regards to page 14, the last paragraph?
Yeah, sure. Dr. Oziel, did you read that paragraph, last paragraph on page 14?
No, I'll read it now.
Thank you.
Yes, I've read it.
And you said in the first paragraph there that the boys were making the point that they didn't kill their parents for money. Is that a statement that they made in unison? Or did they each say that on different occasions?
They each said that on different occasions.
Right. This whole paragraph seems to relate that they were making these statements in unison, and that would be a false impression. Is that true?
No, it is not true. To clarify, this one statement was made at separate points by each of the boys, but that would not necessarily be true of the entire balance of the paragraph.
All right, and at some point in that paragraph, you said you described for them a murder committed in passion and a sociopathic murder. Is that what that says?
That's correct.
Your Honor, the prosecution has indicated that she had an off-the-record discussion with Dr. Oziel in which he set forth some clarification of that statement, and she would not provide that information to us. So I'd ask that it be stated for the record so we know what he told the prosecution was said in regard to that statement.
Do you want to ask him, or do you want to ask me what he said?
I want to ask you what he told you he said.
He told me that he defined sociopathy for them, and that they turned and looked at each other and said in unison, we're sociopaths. Well, I didn't ask him precisely the definition. I just asked him, now, can I just say something?
Yes.
I discussed with Mr. Burt yesterday. I believe that the defense is concerned about the term sociopath. And if the court looks at this paragraph, it says that Dr. Oziel used the word sociopath multiple times. The defense objects to that because they feel that that is an opinion. The Dr. Oziel is giving an opinion. So what I proposed to do was to say, during the course of your discussion at this point, did you describe two different types of killings? And what were they? One was a sociopathic killing. One was a killing in the heat of passion. Did you define for them what sociopathy was at that point? Have them define it and then say what was their response, rather than get into the fact that he had used the term sociopath several times and that they requested a definition. Because to get around the idea that he was somehow calling them sociopaths, instead of just, he gave them choice A and choice B, described them, and then they responded. That was my offer, and that doesn't waive their objection to the use of sociopath, but that was my way of getting around their objection about his possible opinion.
All right, well, without getting into the argument at this point, let's clear up his definition and get through the balance of his description of this conversation so we don't have argument and then testimony and argue back and forth on it.
Dr. Oziel, you say in this paragraph that you described a murder committed in passion. What was the description you gave?
To the best of my recollection, my description of a murder committed in passion was a murder committed without premeditation and without a rational cognitive element, but rather something that arose primarily from the heat of the moment. I believe, or I recall, I gave an example such as someone coming home to find their partner or spouse in bed with someone else or something of that nature, and then picking up a knife or a gun and killing them. And that someone acting out of emotion and without a rational plan was essentially committing an act of passion. It wasn't something they premeditated.
And how did you describe a sociopathic murder?
I described, to the best of my recollection, a sociopathic murder as being a murder that was predominantly a means to an end, something that the murderer believed was a way to achieve a particular end, and it was a planned, premeditated murder and a way to deal with problem solving, and that if there were emotions involved with it, they didn't get in the way of needing to accomplish the end, and that once there was a decision that the murder had to be committed, it was committed, and feelings basically didn't enter into it in a significant way.
And I take it from what you just said, you did not define for them what this problem solving might be.
No, I didn't define anything about the problem solving.
So just in general, it was a murder to solve some problems.
I think what I just stated is the best recollection that I have of what I said.
And how did that discussion get started? Who brought that topic up?
To the best of my recollection, Lyle brought it up. He asked me what a sociopath was.
Was that in reference to something you had said? In other words, had you used the term and he asked you, what are you talking about?
I had used the term, I think, several times in the session.
And that's when you launched into this definition?
No, Lyle asked me at some point, you used the term sociopath, what does that mean?
And it was right after you gave this definition that they both said in unison what you have quoted here in your notes, correct?
That's correct.
Did they stand up and say it, or were they seated somewhere and they both spoke up in unison and said what you have quoted here in your notes?
No, they didn't stand up and say it. They were seated in close proximity to each other, and they were having a discussion, and they looked at each other and affirmatively said, you know, we're sociopaths, or we'd be in that category. And then they proceeded to have a discussion after that of how the murder that had been committed fell along those lines and why they said that they were sociopaths.
And unlike most of the other information in your notes, you have this particular statement that they made in quotes, correct?
I do have it in quotes.
And were you taking that down verbatim as they were saying this in unison?
No, as a matter of fact, I would say that this is a summary or amalgamation of the statements that each brother made, or both brothers made, in the course of their discussion about how this murder took place and why they said or agreed that they would be sociopathic under the definitions that I had laid out.
When you say an amalgamation, are you saying an amalgamation over the course of the entire 4-hour session here?
No, I'm talking about an amalgamation over maybe what could have been a 5 to 10 minute discussion.
That's all I have on that, Your Honor. One more question, Dr. Oziel. When Lyle Menendez asked you what a sociopath is, did you define for him what a sociopath was?
I don't recall ever having defined what a sociopath as a diagnostic category was. I only recall having differentiated a sociopathic type of murder process as opposed to a crime of passion murder process.
Thank you.
On behalf of Eric Menendez, any questioning?
No, Your Honor.
People.
Yes, you have in quotes on bottom of page 14 to the top of page 15. It doesn't have an end quote, but there's this series of statements. Oh, okay, mine, I can't read mine. All right, this statement, it's termed, we just get turned on, et cetera, et cetera. How did that occur? In other words, were they both speaking at once, or was one speaking and the other one affirming? How did that work?
Recalling that these were dictated notes, this is a summary of the different statements that I recalled from the discussion. So what it is a compilation of different statements that approximated as best as possible what I recalled that Eric and Lyle said in that discussion. The actual discussion took place over a more protracted period of time and was much more elaborate than the summary that I had that are contained within these notes.
Now, the statement, we're sociopaths, did they in fact make that statement, each of them together?
To the best of my recollection, they didn't in unison say we're sociopaths. They discussed back and forth and said, well, we'd be sociopaths. And we're sociopaths. We don't follow category A. We follow category B. And then they went on to discuss why they followed category B, why they fell into that category.
Okay, I don't have any further.
All right. Let me ask you this. You phrase this in the present tense. We just get turned on by planning the murder. Once we plan it, nothing gets in the way. Once we start, nothing will stop us. Furthermore, we don't think much about what we're doing before we do it. Once we get going, we just go ahead and we commit it and make it happen. And we can't change the plan because it's already formed perfectly. Were they talking about this particular killing, or were they talking about some other planning that they were doing for some other murder?
I'd be speculating because I didn't ask them that. I could use my best guess based upon what I think was going on in the session to answer that question. Would you like me to do that?
Well, first of all, is that the way they phrase it? They were talking in the present tense.
To the best of my recollection, that is, they were talking about their process, how they operated, and that they were talking in the present tense. Yes, that's correct.
All right. Did they ever talk about any other murders that they were planning, or was this the only murder they ever talked about having planned or were planning?
They never talked about any other murder they were planning, and I might add that they never talked about any other crime that they were planning, ever.
Your Honor, I think based on the court's examination, we raised an 1101 objection to this evidence because I think it does read the way the court thinks it reads, and the witness can't clarify that it is relating back to this point.
Well, it has to be taken in its context, but did the people wish to be heard?
Well, Your Honor, if the court is inclined to feel that the statement is somehow too prejudicial, we would ask, though, that the response of the defendants categorizing themselves as sociopaths be admitted, and the reason that it contradicts the claim of self-defense.
In addition, Your Honor, it seems like it's in the context of the initial statement as to their discussion on why they killed their parents. I think that relates to the initial statement in that context.
Your Honor, I think that Mr. Kuriyama is speculating on what Dr. Oziel, who was there, has refused to speculate on. So,
No, he hasn't refused. He would volunteer his opinion if we asked him.
well, we would object to speculation.
All right. What was your opinion as far as whether this was talking about this particular killing of the parents?
My opinion is they were talking about two different acts, one being the commission of the Calabasas robbery and the second being the killing of the parents, which together formed a pattern. And they were conceptually putting together what happened in each event and concluding that they had a pattern of response.
All right. Again, the opinion rendered by the witness was not one that would be elicited by anybody during the trial. Is that correct? No one wants to have that brought up before the jury. Okay. All right. Anyone wish to argue this matter further? First, the people are arguing that the matter should be limited, or maybe limited just to the defendants agreeing that they were sociopaths based upon the description of sociopathic murder versus heat of passion murder. Is that what you're saying?
Well, what I'm saying is that if the court is inclined to agree with the defense about that entire area in quotes, we would ask the court to parse it, because it seems that we're talking about two different things. One is their self-diagnosis, and the other is the speculation that there might be some inference that they were planning a future crime. So I think there are two separate issues involved there. Mr. Kuriyama made the point that in context, it appears to relate to the murders at hand. But so that was the only point I was going to make, is that I think that the entire thing, if the court's inclined to exclude part of it, it shouldn't all be excluded. And that rather we should be allowed to present by way of testimony that they were given two options and that they picked one of them.
Did the defense wish to respond to that?
Your Honor, I would just like to address a limited issue with
Yes.
regard to the use of the term sociopath.
Yes.
And the whole discussion of sociopathy here. I believe that Mrs. Buzanich has indicated that she's putting Dr. Oziel on as a lay witness, not as an expert. He's merely someone who heard things and is reporting them. When he starts talking about the fact that he used the term sociopath multiple times, I think that there's an inference to the jury that that wasn't.
They're not going to do that.
Well, in any reference by him to the use of the word sociopath is going to be an indication to the jury that this is his diagnosis. And Mrs. Buzanich has indicated to me that although she was not putting Dr. Oziel on as an expert, it was her intention, based on the defendant's adoption of the word sociopath, to then ask our experts, are they sociopaths, which seems to validate through the back door an opinion of Dr. Oziel, which she does not intend to bring in through the front door because she doesn't want to have to qualify him as an expert and go into that battle. So it is our position that there should be no reference to the word sociopath or sociopathic murder, whatever the discussion is going to be about this conversation, that it should not be labeled in that way, because there's an inference of diagnosis there, which she has indicated she does not intend to do. But I think it has that effect.
Yeah, what that means, Your Honor, from our perspective is that if the people want to put on Dr. Oziel saying there are two different types of murder, type 1 is this and type 2 is that, and then have them say, well, did the defendants indicate that they belong to one type or another? Yes, they said type 2, the planned kind. That's really what the thrust of the evidence is for relevancy purposes. And that we would not object to. But to start throwing psychological labels about with a psychologist testifying clearly gives the jury the impression that it is his opinion and professionalism that's infusing that opinion.
All right, the defense position is therefore wanting to eliminate reference to the word sociopath altogether. What is it that the prosecution obtains by using that word that wouldn't be obtained by the defense proposal that the witness described two types of murders, one a heat of passion, one a planned murder done to accomplish an end, as he described it, without letting emotions get in the way, that sort of thing, without using the what can be categorized as a buzzword, sociopath.
If the court is inclined to allow us to present the fact that they diagnose themselves as something, then we can go without the word sociopath. Because as I said earlier, our reason for not putting Dr. Oziel on as an expert is because of these privilege issues. We're trying to just keep him as a reporter of the conversation. And if the court feels that that somehow gets into the area of diagnosis, then we can just have Dr. Oziel indicate that he described two types of murders, type A and type B, or one or two, or whatever we want to call them, and that they acknowledged individually that they belong to category A or B or one or two.
To be perfect. Well, never mind, we'll do that in class.
All right, the court, under analysis pursuant to section 352 of the evidence code at this stage, based upon what has been presented to me, finds that the use of the term sociopath is prejudicial, and the probative value of it is outweighed by its prejudicial effect, since the term has various meanings and could have different meanings to the jury. And the real purpose of the evidence is to lay out a definition for the defendants and provide them with an opportunity to accept or reject that particular definition or description. And there's no need to use the specific word, which does have prejudicial impact. And therefore, the court would limit the testimony to the descriptions of the two types of murder and the defendant's adoption of one versus the other.
And then the remainder of the paragraph onto page 15 is omitted, is that correct?
As of now, it could very well be, depending on how cross-examination occurs, that some of these things would come out. I don't know what the examination will be. But on the people's direct, it does relate to potential, as it's phrased, of committing the potential of committing crimes in the future rather than what had already occurred.
And then the first part of the paragraph indicating that they didn't kill their parents for money, but out of hatred, it's bracketed. Does the defense not want us to?
No, I think that probably should come in.
Yeah, okay, so that's fine.
As context of the statement.
Judge, may I make one further suggestion?
Yes.
In reference to the court's questioning about the present tense and the danger that it's going to be referred to by the jury as referring to some future intent, could we simply change the tense so that it's clear that what they're referring to is this case and not intent to commit crimes in the future?
It's not coming in, Mike.
None of it?
No.
Mr. Bird is shocked at that, so he thinks it probably should come in.
Sorry, I was writing something.
Oh. We can't read any more into that, Mr. Bird?
No.
Try. I think our next issue is page 16. And this, Your Honor, doesn't require testimony of the witness. It seems clear that this is a statement by Lyle about something within only his personal knowledge and reflecting his current mental state, not the mental state at the time of the. That's fine.
All right, that is being offered only as to Lyle Menendez on page 16.
17, this is your, one of your favorite issues, Mr. Burke. This is a joke issue.
Judge, this is not a issue that I need to question him on. I referred the court to a case yesterday referring to jokes, and I made the argument to the court that this is, since it is a joke, as indicated in the transcript, that it's unreliable and should not be put before the jury. It does refer to other crimes, and it has no relevance, and it's more prejudicial and probative.
All right. Did you wish to be heard on that, or do you want to ask questions of the witness? Either of you?
Did you think it was funny?
Your Honor, I didn't check it.
Overruled. Overruled.
Did you think it was funny, Dr. Oziel?
Let him read it first.
I'm sorry, we're on page 17, the bracketed portion that starts several times he made.
I didn't particularly think it was funny.
Your Honor, as far as that goes, the fact that someone says something in an amusing way does not in any way mean that it is an amusing thought, and it does not in any way invalidate the content. And in light of Mr. Stevens' testimony about Mr. Menendez's concern that tapes not be discovered, I think that this is a good illustration of the depths of his concern.
We would be objecting to this because this is not Eric talking, and there's no other evidence that Eric had the same concern since he went to Dr. Oziel to confess to begin with.
That portion would only, the bracketed portion there should only be offered as to Lyle Menendez.
Could I ask one follow-up question based on her
Yes.
question? Your Honor?
Yes.
Dr. Oziel, you said several times he made jokes. How did you determine he was making jokes? You characterized it as jokes. What was that characterization based on?
The best of my recollection is that Lyle had a wry smile on his face when he made the statement.
Like he was joking?
He had a smile on his face like he was joking. There was a wry expression on his face.
And your own characterization in your notes made shortly after this event where he was joking.
That's correct.
Anything else?
No, Your Honor.
All right. Any further argument by either side as to its admissibility?
Just this, Your Honor, in reference to the relevance of this to the statement made by Mr. Stevens, there's plenty of other material on this tape that is detrimental in the way that the prosecution seeks to have it characterized as detrimental. And so I don't see the need for this particular statement, given the fact that it is a joke, to buttress Mr. Stevens' testimony, since the bulk of the other statements can be characterized as detrimental. It would be cumulative under the prosecution's analysis, and it is a joke, as Dr. Oziel indicated.
Well, he doesn't say it's a joke. He just said that that's the way it was phrased by the defendant, whether it's taken as a joke by the person who hears it as something else.
But the relevancy, Your Honor, is what the intent of the speaker is, not how Dr. Oziel took it.
Yeah.
He says several times Lyle Menendez, made jokes. So
Yeah.
I think in Lyle Menendez's mind, it was a joke.
But a joke can carry with it the person's thoughts and concerns, whether it's said in a joking fashion or not. And that's the issue. And it relates back to Mr. Stevens' testimony, which was impeached substantially by the defense on various issues, and relates to the defendant's concern that these tapes be found. And it's followed through later on the same paragraph in an area that's not bracketed and not objected to by the defense. Similar concerns.
I think
So I don't see where there's prejudice here. I really don't. And it's not other crimes. As it's phrased, the defendant would be acting as a good Samaritan in protecting Dr. Oziel from an atrocious felony being committed upon him. So that's hardly another crime.
Well, shooting someone in the back could be characterized by some perhaps not by all, but some people would think that shooting someone in the back is another crime.
As that
And-
person was shooting Dr. Oziel, the defendant would shoot that robber and protect Dr. Oziel. That's the way it's phrased here. So it sounds like the defendant would be defending Dr. Oziel against imminent danger of death or great bodily injury.
Your Honor, the Montoya case that I cited to the court yesterday indicates that a statement made in jest is simply not a reliable indicator of someone's state of mind. And the court speculating about how a jury would view this and whether a jury would view this in the same light the court is completely, it's unnecessary to do that when, as the court just indicated, there are other statements along the same lines which are not indicated in a joking manner that the prosecution can use to buttress the inference they seek to buttress in regard to Mr. Stevens. So it's cumulative, and it does have a prejudicial implication.
All right. Is there any objection to the last phrase there, starting at the word several on page 17 by either defendant?
Well, we would object.
Well, you didn't before.
You seem to be inviting it.
No, I am just responding to Mr. Burt. I assume Mr. Burt isn't objecting to it on behalf of his client.
I don't really object. I don't see.
Okay, and why is it that the people need the upper phrase then, which does carry the joking connotation, when you have the bottom portion of it, which carries with it the same concern?
Well, Your Honor, because this is a specific statement of Menendez, which indicates his desire and distrust of Dr. Oziel. In other words, the desire to reform is sort of uneasy alliance with Dr. Oziel, but at the same time, his fear that somehow these tapes are going to get released. And I think it's a specific statement of his intent in regards to his approach to Dr. Oziel. And it's a vivid one as well.
That's the
And
problem.
you can create a mental picture of this scenario, and I think that that is a good way of describing the intent that Lyle Menendez had towards Dr. Oziel.
Submitted.
All right, the court finds that although this is a joke or expressed as a joke, there is the thought there and the deep concern expressed by the defendant, and it's a direct quote and description of the defendant, Lyle Menendez's concerns, and is corroborative evidence of the concerns he also vividly expressed to Glenn Stevens on the airplane. And the court finds that the probative value of this substantially outweighs any prejudicial effect, and it will be received as to the defendant Lyle Menendez only. And the latter portion of the page 17 completed on page 18 would be received as to both defendants. Then going on to the next bracketed portion, that's the bottom of page 18, starting with the word Lyle. Going on to page 19, the completion of the first full paragraph. Is there any questioning of the witness in regards to this by either defendant?
Not at this point. We intend to have an in-camera hearing that is somewhat relevant to this. My recollection is we discussed part of this before, and the people indicated that at least the last sentence was not being offered because it makes reference to the privileged tape.
Yes, that's correct, Your Honor. We can omit the last sentence, starting with, it was Lyle, then that.
Okay, but we're objecting to the preceding part because it has minimal relevancy. It also has to do with the privileged tape, since no tape recorder is being used in this particular session, and the only time that it was used for a tape that's been removed privileged.
All right, so the defense...
And this is all Lyle's attitude in here anyway.
The defense concern is that by reference to a tape recorder, this somehow could relate to something that happened in the future. This was, when this conversation took place, it was on November the 2nd. And your concern is that somehow it would make reference to what did occur in the future, the conversation on December 17th, December the 11th between the witness and both defendants that was tape recorded and that was subject of the hearing in the Superior Court. And my recollection was that the court then ruled, the Superior Court ruled that his analysis was that the content in December the 11th conversation was basically the same as what had occurred earlier, and that ruled it not privileged because of that. And the appellate court sustained that ruling on some other ground, and then the Supreme Court ruled that it was privileged.
Right.
And so how is this jury going to be made aware or concerned with something that happened on December the 11th when this is a conversation that took place on November the 2nd?
Well, I think it's obvious from the publicity questioning. I mean, if this jury were completely in the dark and knew nothing about this evidence, then there'd be no way for them to understand the linkage or to speculate. But we do not have a pristine jury here. Virtually every person on our jury has heard about this case. And the number of people sitting on this jury heard about a tape in which the defendants' voices appeared and the court questioned them and we questioned them. Well, if you're a juror and you don't hear that tape, well, you think we're keeping something back from them, blah, blah, blah. And this, I think, is going to suggest to them that such a tape was made. And because our jury has pre-existing information, this might ring bells that it would not ring, granted, on the face of it, with a totally uninformed jury. But I think we know that we could not get rid of all the people who had heard about a tape with the defendant's voices.
I think there are very few of those jurors, if any, that I don't know if there are any on either of these juries. I haven't looked at the questionnaires, but my recollection is that most, if not all, the jurors were excused that had specific recollection of a defendant's voice on a tape versus just the existence of tapes, which is clarified by this witness when he testifies that he dictated his notes on tape.
I think Juror Tracy Miller answered, but I'll bring in the juror responses.
Okay, regardless of that, just the people seem to concede that this need not be brought out. Is that right?
What I want to put in front of the jury is, starting at page 19, the second line, starting with, because he wanted the notes to accurately reflect things that he thought might mitigate the severity of the crime he committed in the event he was ever caught, he wanted me as a witness. I think that at this point, we can delete reference to tape recorder at this portion. Now, earlier on, Dr. Oziel indicates he's keeping notes and they're in a safe deposit box. But as far as this particular section goes, I think that we could just say that Lyle was concerned that he keep notes which would accurately reflect things that he thought might mitigate the severity of the crime. But I also believe that I'd like to ask the witness a question about what Eric Menendez's response was, if any, to this discussion.
All right, sure, you may.
Dr. Oziel, are you familiar now with the portion of the conversation we're talking about that concludes on page 19, that first paragraph?
Yes, I am.
And in this discussion of having the notes accurately reflect things that had occurred, I believe at the beginning of the paragraph, you say Lyle in particular was very concerned. When you say Lyle in particular, was Eric at all involved in this?
Yes, he was.
Could you tell me to what extent, please?
Just passively nodding his head or affirming, or he wasn't actively initiating the concept. That was Lyle.
All right.
Eric was sitting there and.
All right. Did he in any way disagree with the idea that you should in fact become a witness, or that you might be able to help mitigate the severity of the crime by your knowledge of events?
I don't recall Eric making any specific comments about mitigating the crime at that time.
All right.
All right, any further questioning of the witness?
The one statement you have there, he needed me as a witness. Who made that statement?
I think it was a discussion actually between myself and Eric and Lyle that reflected the possibility that my ability to piece together what had happened in the family constellation might, in the event that they were ever brought to trial, be significant information that would help jurors understand something about why these murders took place.
Your Honor, I would object to any such testimony from the witness because it clearly relates back to his knowledge of the family during the time of prior to any homicide and prior to any threat. And so to expand this conversation to relate back to what Dr. Oziel may have gained when he still had a totally confidential and privileged relationship with both defendants, I think conveys that privilege.
We join in that, Your Honor.
All right, do the people wish to be heard?
Well, I'm unclear. Is it that the defense doesn't think this one phrase, because he wanted the notes to accurately reflect, should come in at all, or that the expansion shouldn't come in?
Well, two things. I think we have to break it down. There are two different things here. First of all, we're objecting to the specific language here that is Lyle's, that he wanted the notes to accurately reflect things that he thought might mitigate the severity of the crime he committed in the event he was caught. Dr. Oziel just said Eric never made specific comments about that. He was sitting passively nodding at some points in this conversation. The second phrase, he needed me as a witness, we still don't know who he is, but the explanation for, in other words, apparently no one made the statement, I need you, Dr. Oziel, as a witness. It was a conversation in which Dr. Oziel and whoever was talking about how Dr. Oziel could piece together the family constellation, which refers back to historically. So the objection would be even to the phrase, he needed me as a witness, since that doesn't seem to have been said, but is simply a summary of this other concept that relates back to private therapy.
All right, people wish to be heard. Response to that.
May I ask the witness?
Yes.
Did someone actually use the phrase, I need you as a witness? Or was that your conclusion?
Actually, I think that I might have said in the event that you come to trial, it potentially, if you're ever brought to trial, potentially I could be a witness. And I think that, I'm not stating that I initially stated that, but I think I might have used the word witness before they ever adopted the word witness. Lyle, prior to that, had talked about how it would be good to get this down on tape and to get all the details down on tape to mitigate in some way the severity of the crime that had taken place, to try to explain what happened. And so I said, yeah, it's potentially the case that in the event you're brought to trial, that I could be a witness.
Okay, Your Honor, then we would not offer the phrase, he needed me as a witness, but we would offer the phrase that Mr. Menendez wanted the notes to accurately reflect things, et cetera, et cetera.
Is that limited to Lyle only?
No, it's people's position that this is an adoptive admission as to Eric Menendez as well.
Can I ask the witness a question?
All right.
Do you specifically remember, Dr. Oziel, any reaction by Eric to Lyle saying specifically that he thought it might mitigate the severity of the crime in the event he was caught? You're having accurate notes.
Yes, I don't remember specific sentences that Eric spoke, but I do remember that there was a discussion between myself, Eric, and Lyle, and that there was basically an agreement that that might be a good idea.
You just testified 3 minutes ago that Eric made no comments about mitigating the severity of the crime. Are you changing that?
No, I think what I'm trying to clarify is that I don't recall any specific statements that Eric made, and I could not testify that he made any comment about mitigating the severity of the crime. But in general, the conversation about the possibility that it would be useful to have these things on tape is something that was a discussion that was initiated by Lyle, and that it was between Lyle and Eric and myself, that it was possible that that could be of benefit in the event that they were ever brought to trial.
All right. Did you wish to be heard further?
No.
All right, the court will rule that this was an admission made by Lyle Menendez, adopted by Eric Menendez, and will be received as to both.
With the further understanding that Dr. Oziel will not be referring to tape recordings, but I'll phrase the question in terms of notations or notes.
All right.
Your Honor, as to the last bracketed portion on page 19,
yes,
which I believe starts, counsel, Mr. Burt, Does it start with Eric recounted his father's near disinheritance of him?
Correct.
All right, we would offer that as to Eric Menendez only, Your Honor.
Your Honor, I need to be heard on that in camera.
Okay, this was an area you felt dealt with a privileged conversation or
Yes.
something else? Okay.
Or that imperils, it impacts the privilege to be able to adequately cross-examine on it.
All right.
I'd like, we need another hearing in camera anyway, so we can do this piece first.
All right. That seems to take care of all of the objections that either defendant has raised in the statement or both statements here. At least those that have been identified by the parties by bracketing the areas of concern. And there are some limited areas apparently that counsel wish to explore with the witness in camera. But before we do that, let's deal with any other matters that relate to this witness's testimony. We'll do that in open court here. Any other matters that counsel have that you want to address, such as impeachment or anything else? There was some offer of proof that the defense was going to make in regards to efforts to impeach the witness. Or do you have other areas that you wanted to inquire of the witness in regards to his testimony in general?
Can I have one moment?
Yeah.
I'm confused.
Does the witness need to remain on the stand?
Only if there are some questions that will be applicable.
There may be some, in reference to the offer of proof yesterday, the specific acts that were outlined in the complaint filed by the Attorney General's office. And it's my understanding Mr. Brunon may want to be heard on that. So I would prefer, if we're going to have an in limine motion on those aspects, that the court defer at this time, considering those issues. Also, we may and will at some point make an offer of proof through independent witnesses. And I think that whole issue is best dealt with at another time.
Well, I'd like to have it resolved so the witness will be able to testify without further interruptions and further delays. So if Mr. Brunon is coming today, then we can discuss it today.
Your Honor, Mr. Brunon indicated in the message to us that he would be about 10:30, so we do expect him to be here.
Right.
He also indicated to us that he had something in the way of a motion to file with the court seeking to preclude us from going into certain areas. So I don't know what that's based on, but I'd like to take a look at it before we question the witness further.
Yeah, okay, we will do that, and we'll do it today so we can get it resolved. Let me go back to page 13 of this document because there was something that we had deferred that had to do with the first bracketed portion on top of that page, dealing with other crimes or future crimes. And that falls within the same discussion we had regarding sociopaths and that paragraph, and the court had deferred ruling until we got to that. And what is the people's position as to why this should come before this jury?
Are we talking about the top one that says then Eric mused that?
No, we're looking at this whole,
Oh.
this whole paragraph that future crimes and crimes on the previous page, that each of them independently began thinking.
Right. Just a second.
Okay.
Can we have a moment, please?
Yes.
Yeah, we would offer only as to the extent that it deals with, that they said it was important to commit perfect crimes, period, not future crimes.
I think that's the crimes of future crime context. It's different than saying commit.
Well, okay, I don't want to have people back and forth. If I invite argument or if you ask to be heard, you can be heard. What is it that you're proposing?
That they indicate, that the defendants indicated in this discussion that it was important for them to commit perfect crimes, period. Leaving out that they had a belief that they could commit further crimes and never be caught. When I tried to tell them I thought this was exactly kind of dangerous thinking, etc., omit that portion, but just leave it as starting on page 12 that they in both indicated the necessity of committing further crimes, which is reference to the crime they committed.
Or you're proposing to edit this in some way?
Yes. Yes, edit it by taking out the reference to future crimes and the concern or the expression of concern by Dr. Oziel that this might lead to further crimes, and then they said they didn't think they'd commit any future crimes, leaving out that portion.
All right, did the defense wish to be heard?
Yeah, well, for one thing, when Dr. Oziel testified about this, he said, first of all, that the word thinking was not the right word. It should have been the word discussed. And that he didn't remember the individual sentences, that this was an impression that he formed based on their discussion. So what we've got now is an impression that's going to be edited, and that's still going to give the impression to the jury that these defendants at that point on November 2nd were thinking about or discussing how important it was for them to commit, not to have committed, but to commit perfect crimes. And I think it's clearly going to be read as intent to commit future crimes. And yet Dr. Oziel has already told us they never indicated to him any such intention.
All right, well, it basically has already covered in other discussions when on the bottom of page 11, both defendants agree that they were involved in this plan. The plan became so rigid once it was formed, and it was believed that it was the perfect murder. And I'm quoting there. So it's already referred to as a perfect crime. And there are other references as well in the transcript to that. This area, again, does go into the other crimes, other acts that might cause a jury to speculate that the defendants were planning other crimes. And that is the type of information that is prejudicial, and under Section 352 of the Evidence Code, that portion would be excluded as to each defendant.
Could I ask what the prosecution's theory is for why the last sentence in that paragraph is relevant?
All right, that's already been ruled on. You had indicated you wanted that in.
No.
You're talking about then Eric mused?
Yeah, only if the rest was in, but if the rest isn't in, I don't want that in. It's so bizarre. And it's just speculation, it has no relevance to the crimes. Even though the doctor said he was sad and concerned when he was saying this. I like sad and concerned, but I don't like the subject matter, and I don't think it's relevant.
Did you wish to be heard?
Yes, Your Honor, I believe we already argued this, and I believe the court ruled it was an adoptive admission. And its relevance, does the court wish for me to restate it?
No, if you're satisfied with the record you've made and your position is the same.
Yes, that it negates the defense being offered.
Okay. All right, the court did rule on that, and at one point the court gave the defendant, Eric Menendez, the opportunity to opt into that one. They did. Now they're trying to opt out, but regardless of the defendant's position, the court finds it's admissible as to both. As an adoptive admission as to the non-declarant, and as an admission by the declarant. All right, anything else? All right, other than the hearing in camera in regards to this witness, and the hearing in open court in regards to impeachment evidence and any objections by Mr. Brunon and the prosecution, is there anything else that relates to this witness's testimony?
Your Honor, I just had a question that really doesn't relate to his testimony. I don't know what the court's doing in camera, and I guess I'm not supposed to know, but if the defense is going to raise the attorney-client privileges to the December 11th session, I would like to give the court some things to look at if that's in fact going to occur. Is that what's going to occur?
Well, we indicated to the court that was one of the purposes for the in-camera hearing.
Your Honor, there were findings of facts rendered by Judge Albrecht at the hearing, and one of the findings, and I have made copies of the findings of fact.
Okay, perhaps
For
you can
everyone.
give that to me as well. I don't,
Yes, I have a copy for the court.
I don't have it. I'm sure it's in the court file somewhere, but
Yes.
rather than fish around for it, you can give it to me.
And I would also again refer the court to section 1524 of the Penal Code, which talks about the fact that at a 1524 hearing, that all privileges can be raised by a privilege holder. And I think that there were findings of fact regarding the relationship between Dr. Oziel and Mr. Chalif. And since I wasn't there, I can only assume that what I have in my file are the findings of facts of Judge Albrecht.
Okay, well, we're talking in the abstract here. I don't know any of the specifics of what occurred and what the findings were, and all of that can be argued after I hold this hearing, so I know a little bit more about it. But let's take a recess now and see if we can find out where Mr. Brunon is, and if he has some document to file, counsel can look at that, and we'll resume at 15 minutes after the hour. Resume with the hearing. I understand that Dr. Oziel's counsel is not available this morning.
Yes, it appears he will not be here before noon. I would suggest that if there's going to be an in-camera hearing, perhaps we could do it now in hopes that maybe he'll arrive before then. In addition, we still have the issue of the transcripts. I received one date so far. And 2 dates so far, Your Honor. I think we need to talk about scheduling in terms of, I would like to make copies of these for Dr. Oziel so that he can have them this weekend to review before he testifies. And my suggestion was going to be that we put his testimony on Tuesday instead of Monday. Now, I know that we have the jury. Eric Menendez's jury is coming back at 9 and Lyle Menendez at 10:30.
Yes.
Then what we will do is put on the September 17th statement as to Eric for that period of time. Is that all right?
As I say, you can call the witnesses in whichever order you want to, as long as you fill up the day, and we don't have a gap there of half a day with nothing for the jury to do and nothing for the court to do.
No, we will, and then I have Dr. Golden scheduled for the afternoon, but we have a number of other witnesses who are on the last witness list I provided everyone. The Haymans, Mr. Whitkin. So it looks like we'll have more than a full day. I just want to let everyone know that I think because of these transcripts that we're going to need an extra day.
All right, in regards to those transcripts, the district attorney indicated that you wanted me to review the transcripts to determine whether or not the editing done by the defendants accurately deals with, or correctly deals with the claim of privilege that is being asserted by the defendants. Is that correct? Okay, I haven't seen these transcripts, and counsel will have to provide me with the redacted versions as they have been presented to the district attorney.
There are 2 volumes, 2 redacted volumes. This is June 28th, 1990, and July 30th, 1990. 2 other volumes, Your Honor, I have to make some corrections on, so
Right.
I will get those to the court in a second.
And I assume these are the portions that have been turned over to the prosecution, is that correct?
Exactly.
And,
You have complete sets somewhere.
well, if I do, that's helpful to the court. If I don't, then counsel will have to provide those to me.
If you don't, but you should.
Well, these are things that occurred in 1990, and whether all of the materials have arrived here is problematical. Let me ask you this, just in thumbing through it, there's things blacked out. Is that the portions that you have deleted or redacted?
Yes.
And otherwise, the entire transcript was given to the prosecution except for these redacted portions?
No. There, on one of them, there's a note that says the next few pages aren't because of privilege. I would have had to have blacked out every single word on the next few pages.
Okay, but you've noted that in the
Right, I noted
document.
that on what I turned over, and also I didn't turn over the testimony of other witnesses. I mean, for example, following Dr. Oziel on July 30th was Detective Zola's testimony, so I didn't turn that over to them because it didn't bear on this issue.
All right.
And I'm sure he can tell them if it was the same.
All right. I'll review those, and I'll review the others when you present them to me and to the prosecution. What else do you have that you want to do at this point, besides the in-camera hearing?
Well, I believe we're going to deal with the issue of impeachment, and I would suggest we do the in-camera hearing first, and if we have time to do the impeachment before lunch, and Mr. Brunon doesn't get here, then we'll just do it.
Well, I assume we'll do the impeachment with Mr. Brunon present.
Well,
That's why he wanted to be here, is that right?
But he indicated to Mr. Toriyama that if he couldn't be here, we'd have to go ahead without him. He's waiting downtown for a judge to appear. The judge wasn't there yet, I understand.
Well, you said that he would be here at 1:30.
No, I don't.
He indicated he would be here as soon as possible. He's in Judge Reed's court downtown, Your Honor, and he thought he would have been here at 10:30, so he did call him, Dr. Oziel called him on the break.
Well, I'm going to give him the opportunity to be here, and we can do it at 1:30, and if you're ready to do the in-camera hearing, we can do that. Are you prepared for that?
Yes, Your Honor. I was going to make one suggestion with respect to Mr. Brunon, which is that perhaps the court could defer that whole issue until, as the court indicated, we need to make an offer of proof as to independent witnesses, and we would be prepared to do that, and if need be, recall Dr. Oziel on those issues. It's a discrete part of the cross-examination that I think we could segregate out from the rest of the cross-examination and also from the independent witnesses that we would intend to offer. And I think it would be a better use of the court's time if we scheduled a 402 hearing on those independent witnesses, as well as the scope of cross-examination on Dr. Oziel on those specific acts that we would be offering.
Well, those are two different issues. One would be a hearing, which I assume would be conducted sometime during the defense presentation of evidence. And the other would be a discussion regarding the scope of the cross-examination. And we can do that, and we should do that before he testifies. So why couldn't we do that this afternoon?
Well, because I'm indicating to the court that we're prepared, at least I'm prepared at this point, to defer any cross-examination on these acts until the court has had an opportunity to rule on the offer of proof as to the independent witnesses. And I'd also like to see what it is that Mr. Brunon is going to be filing and respond to the court in writing as to what our position is, so that the court is aware of it and we have the opportunity to look at what arguments he's making. And I think I would agree that I wouldn't go into those areas during the cross-examination with Dr. Oziel until the court has had a chance to look at whatever papers have been filed and to hear from the independent witnesses as to the offer of proof. Because I think the issues are related.
I take it, though, that you would want to recall then Dr. Oziel during the defense for further cross-examination, or how are you proposing to do that? Because the people apparently are going to be resting next week, as far as I understand it.
Perhaps, but for instance, if the court were to rule the independent witnesses admissible, it may be the defense's position that we wouldn't need additional cross-examination of Dr. Oziel. It would depend on the scope of the court's ruling as to the independent witnesses. And if we did need additional cross-examination, we could recall them at that point in the defense case when we would reach that issue. And it may be that it's unnecessary and premature for the court to go into it at this point because the defense may decide to do it some other way. Or the court may hear from the independent witnesses and make a ruling that would cover Dr. Oziel. I just think it's a better use of the court's and counsel's time not to do this piecemeal with respect to this one issue. And I would like the opportunity to brief the issue for the court.
Right. Do other counsel wish to be heard on that suggestion?
I just wanted to say, I know Mr. Brunon's starting trial on Monday. I don't know how long the trial is, and I don't know when Mr. Burke wants to do this, but if we do have time available today and we can resolve some issues, I think we should try.
Well, let's see if Mr. Brunon shows up and if he has anything with him that he's filing, and we can certainly have a better understanding of the situation when he arrives. So let's hold off and see when he arrives, if he does. All right. Then are you ready with the closed hearing?
Yes.
Okay, then we'll close the courtroom and conduct a hearing with only the defendants and defense counsel present. Are the parties ready to proceed with any matters relating to upcoming testimony, whether it's Dr. Oziel or anyone else?
I don't know.
I think Dr. Oziel's here with his attorney, and also the other thing we could do is the court was going to make a ruling on the refusal evidence.
Yeah, I'll do that today since the people haven't submitted anything else that they indicated they intended to deal with it today. And since the people haven't submitted anything else to me, I'll deal with it today. And before we do that, as far as Oziel is concerned, Dr. Oziel and his testimony and the efforts the defense will make to impeach his testimony. Any further thoughts as far as how you wanted to proceed?
Well, Mr. Brunon stated to us he was going to make a general objection to the court, and I indicated to him that it was our position that it was premature at this point to litigate specific acts that Dr. Oziel might be cross-examined on until sometime after his direct testimony and after we decide whether we're going to pursue that avenue through cross-examination versus independent witnesses.
Well, if you pursue it through cross-examination, we have to have a hearing before you get into it. So how did you want to deal with that?
I understand that, and it would be our position that we would complete our other cross-examination on appropriate issues that the court, I think,
on more traditional
traditional grounds, I should say the non-contested issues, and then at that point, I think it would be our position that during the defense case, we would make an offer of proof as to collateral acts and independent witnesses in support of those acts, and at that point, recall Dr. Oziel as part of our case.
All right. Well, the way this all arose is the prosecution's motion to limit or exclude any impeachment on the complaint filed by the Board of Psychology and the specifics of the allegations in the complaint. So the people should have an opportunity to state their position in this matter as far as how you want to proceed regarding the impeachment of Dr. Oziel.
Well, if I could be very briefly on one aspect of this.
Yes.
We just got that complaint along with it at the same time that everyone else did, and it led us to a new interview with a new witness, which we haven't even conducted yet. One of the problems with our going through any specific other acts today is that we haven't interviewed one of the key witnesses. And in fact, we have not re-interviewed Ms. Smith with this in mind. And so both of those interviews are shortly to be conducted. So we're really not in a position to tell the court which specific bad act we would want to use, either in cross-examination or with the collateral witness, except for the material with respect to one of the two people referred to in the accusation. We have turned over the prosecution discovery vis-a-vis that witness. But again, I don't see any necessity to litigate that now because I don't anticipate cross-examining this time on those collateral matters. I do intend to cross-examine, as the court indicated we could, on that aspect of the accusation that relates to this case.
All right. Did the people wish to be heard on the remarks so far?
Well, then is it the understanding or the agreement that there will be the traditional cross-examination and that specific acts that they want to use to impeach will be presented in their case with the option of either us recalling Dr. Oziel to rebut them or them calling Dr. Oziel for the cross? Is that what is being proposed?
That seems to be it, with the exception of those references in the complaint or accusation, as the document is called, that relate specifically to this case, and that relates to the sessions that were conducted with the defendants and the disclosures made by Dr. Oziel of their content. And
so insofar as it relates to Ms. Smith then?
Yeah, well, only in regards to that portion of
right.
Ms. Smith's contact with this matter or with Dr. Oziel, nothing to do with other allegations that are attributed to her in the accusation.
I should indicate, though, that I think what Mr. Burke just said is if we decide we do want to confront Dr. Oziel during cross-examination with these collateral acts, we would have 402 hearings at that stage after our traditional cross-examination is complete. So there will be an opportunity to be heard on that before we do it.
Yeah.
Just have to put the previous concern.
Yeah, that's what she just said.
All right, well then, I'm wondering if the court would like to hear from Mr. Bruno, since he will not be available next week when this process may occur. And I think he just wants to state his position.
Well, as I understand it, the defense probably wouldn't even get to it next week, what they're saying.
I got the impression that they're going to do the traditional process and then they may ask for 402s next week. Isn't that what you just said?
That's possible,
I think it would be that quick.
Yes.
All right, well, we can hear from Mr. Brunon if you care to present your position.
May I use the podium here?
Certainly.
Thank you for the opportunity to address the court. And
glad you could make it.
Well, yeah, Judge Ito to thank for that, but since he's the presiding judge. Your Honor, I recognize and acknowledge that as an attorney for Dr. Oziel, we don't have the standing of a party here, and I don't intend to proffer my comments as if I were representing one of the parties. However, based on some of the comments that I've heard the last couple of days and read in the paper, I do think that Dr. Oziel's unique position needs some amplification so that the court, when ruling on what counsel is characterizing as collateral matters, in which I would heartily concur in that characterization, will have some sense of the background, the larger factual picture, which may not have been presented to the court thus far. And I suppose it belabors the obvious to re-inform the court that Dr. Oziel is not a volunteer witness. He was initially subpoenaed by the people and ultimately ordered by the Superior Court and after that by the Supreme Court to give the evidence that he has been required to give. So he has been impressed into duty, if you will, and has not voluntarily placed himself in this forum. In regard to this accusation that is the subject of the debate at the moment, I don't think that there's any criticism in allowing full examination on the areas that the court has indicated relate to these transaction and underlying facts. That has been the subject of litigation before the Supreme Court, and I think it's obviously appropriate to go into that. But I think it's important for the court to know that these accusations that are contained in the balance of that accusation have previously been investigated by the Beverly Hills Police Department on two separate submissions. There was an initial complaint made by the complainant. That was investigated. It was found to be not meritorious. It was again resubmitted to the police department, again investigated and taken to the district attorney's office, where it was rejected for prosecution as not having sufficient credibility to form the basis of an accusation. And in addition, the complainants in that accusation, JS and AK as they are known, at least for those purposes, have both told all of the parties here in interviews and in some of the parties out here, news interviews and other interviews, that they were never patients of Dr. Oziel. So when the question of professionalism and practice comes up, I think it's important to note that it is simply an assertion that they were patients. There's no evidentiary foundation for that assertion, and from their own words, consistently, they were not patients. In regard to the impropriety or the alleged impropriety of taping some of these sessions, I think the evidence will show that that was done consensually. And the revelation of the contents of some of those sessions has already been approved by the Supreme Court, in fact, compelled by the Supreme Court. So I don't think that re-examination of that, at least in a sense of being vilified for doing what was compelled and condoned, would be appropriate. So those are the matters that I felt it would be appropriate for the court to know, at least from Dr. Oziel's position, because when you do the weighing that you're going to be required to do, I think that the nature of the dispute and how it would have to ultimately be resolved is one of the factors in weighing, at least in the consumption of time, and I thought that might assist the court. The other thing is that as a result of these news stories that were aired last week, Dr. Oziel has received a rash of threatening telephone calls and communications, and we've informed the appropriate authorities about them. But again, these things are not controlled rationally, and we were informed just this afternoon that there is a process whereby we can make a request of the court to not broadcast Dr. Oziel's testimony, at least his visage, on live television. And if there is such a process, and if that's open to Dr. Oziel, we would like to take advantage of it for those purposes. And if the court would like further elaboration on the nature of the threats and communications, we could do that either at sidebar or in camera if you feel that's appropriate. So I just, I don't know, I don't want to be frivolous, but in reading the threats to impeach Dr. Oziel by every manner known to God or man, I'm sorry, man or God, or woman or God for that matter. I just wanted to be in a position to assert Dr. Oziel's right of privacy protected by the California Constitution, and perhaps ask the court to consider that when making these rulings.
All right. Did anyone want to respond in general sense to what Mr. Brunon has stated here?
Just to indicate to the court that we're using the term collateral because that's the way the court characterized it. We in no way think this is collateral impeachment, but I think Mr. Brunon's comments are made in the abstract and in general without reference to the specifics of the cross-examination. And that's why I think at this point the court is really not in a position to conduct the weighing process until a court hears some testimony from Dr. Oziel and see what areas he opens up in his direct testimony, and hears the specifics as to the offer of proof that the defense will make as to how these acts are relevant and relate to this witness's credibility, which we feel is a central issue in the case. Whether he feels he's thrust into the case or not, he still is a witness for the prosecution. And it's our position that we're entitled to attack his credibility just like any other witness.
All right. Well, it's understood, and Mr. Brunon's remarks were taken with the understanding that his were general remarks and not specifically addressing the allegations that will be made or that you will attempt to make. And we'll have to wait until you do that before we get to the specific rulings and weighing process. As far as the request regarding televising the testimony, if there was something specifically that you wanted to disclose to me, that you wanted to, for reasons of personal safety or otherwise, to disclose in a closed setting, I'll give you that opportunity to do that.
All right, I would so request, Your Honor, and I can stand by here a little while longer if that's...
Okay. There's not too much more here before we'll take a break anyway, so you can do it
thank you.
Probably within the next 15 minutes.
Thank you.
Your Honor, as far as the refusal evidence, I would ask an opportunity to do some further research over the weekend, and could we then maybe argue it Monday or Tuesday? That evidence is very brief and can be put into the case at any time before we rest.
All right. If you wanted to provide me with something else, I'll be glad to give you the opportunity, but let's not keep it in abeyance forever here so that we can complete it. Anything else here before we recess for the afternoon?
No, Your
Honor. There are some other 402 issues having to do with witnesses that have now been rescheduled
Yes.
for Monday.
And
I think Mr. Kuriyama agrees. I don't think we've had a final ruling on the Howard Whitkin evidence. That's the person that Lyle met with vis-a-vis the computer. Nor have we had a final ruling on the Hagen testimony, which are the people that Eric met with, that Carlos Menendez set up the examination of the computer. I think we're sort of hanging on those.
well, when you say final ruling, you are objecting to this, and what is the position, or what is your objection?
Well, let me just say, Your Honor, that the people previously had indicated when this issue first came up and we had cross-litigated it, that they weren't seeking to introduce the Whitkin evidence against Eric Menendez, so we never really argued it. And with respect to the Haymans, the court had raised some questions as to why it was relevant that Eric is there facilitating his uncles wanting to look through this, or cousin, looking through the will.
Yeah, then there was a different offer of proof by the prosecution in their, I believe, one of their written documents relating to that incident and as it related to Craig Signorelli's presence at the house. You know, pinpointing the date and time of Signorelli's presence there and corroborating his testimony.
Well, but to use this kind of evidence to corroborate Mr. Signorelli's date and time of being there, I think it ignores the balancing process that's necessary as to whether or not, you know, first of all.
Well, it's already come out in Signorelli's testimony
I
that
understand that.
Eric Menendez's jury has already heard it.
Well, they heard that, you know, Signorelli's version of it, but I still don't see the necessity to have the Haymans testify to what went on.
Well, you cross-examined Signorelli at length on that particular incident with the impression that you disputed that he was present when that occurred and that it could have been someone else. And it was quite clear that there was an issue there that the defense was raising as to whether or not Signorelli was even there at that time. So it seems to me that it certainly is relevant and probative, and I've already indicated that I did a balancing under Section 352 of the Evidence Code when we discussed it before, and that it was admissible that the prejudice was nil and the probative value was substantial, and further that the people would make clear that, and it was brought out, I believe, already in the testimony of Signorelli, that this individual was hired by this fellow Carlos.
On the contrary, Mr. Signorelli testified that he believed Eric had arranged to have.
Okay, then when Mr. Heyman comes in, he can clarify it as to who hired him.
Yeah, there seemed to have been a circle involved here because it seemed to me that we objected to the Heymans and there wasn't a ruling, and then we objected to Signorelli testifying to it, and the court let that in, and suddenly we're back to the Heymans.
No, it came out in regards to the people's offer of this evidence to corroborate Signorelli. And that's why the court let it in, and we had a discussion at that time, and I did a weighing under Section 352 of the Evidence Code at the time we discussed it, and it was admitted at that time.
Do you remember what day that was, Judge?
No, it was before Signorelli's testimony.
It's just getting a little, obviously, if I'm wrong, I'm more than willing to admit it, but it's confusing.
Well, it came in, and it came in under during the testimony of Signorelli, and my view is that it's before the jury, and the people should have an opportunity to bring in the Heymans to testify to that event.
Well, we're still objecting, however, to the Witkin evidence about what happened when Eric was not present, Lyle's hiring Mr. Witkin, how that occurred, what was said during that, all of which is hearsay now. So
I haven't heard that the people were offering that against the defendant.
It goes to Eric Menendez's state of mind. I believe that Craig Signorelli testified that on the day that the Heymans were there to access the computer with regard to the will, that Eric Menendez had a conversation with Craig Signorelli and indicated that his brother had someone come the previous day to delete the computer. So I think it is relevant in regard to Craig Signorelli's testimony. So I think that not only Mr. Witkin, but the Heymans, both computer experts, should be able to testify in this matter.
But Your Honor,
Let's hear your response to the Witkin evidence.
I think what will come out from the Heyman evidence is that they tell Eric that the computer has been wiped out, okay? And Eric then makes a series of phone calls, which Mr. Signorelli didn't remember at all. And in the course of the phone calls from the Heymans, what their evidence is that Eric learns that his brother has been there when he's on the phone. So there's no evidence. I mean, the people cannot assert and don't assert that Eric was there when Mr. Witkin was there, and they have no evidence of Lyle ever telling him what he did. But we know from the Heymans that Eric learned what happened from the Heymans, basically, and then making phone calls, talking to Carlos Menendez, finding out what happened. So I don't think that the Witkin evidence adds anything to that.
People wish to respond to that.
Yes, Your Honor. It was the testimony of Craig Signorelli that Eric Menendez knew at the time that they were accessing the computer that his brother had hired a computer expert the day before. What he told his uncle on the phone, which Craig Signorelli was not privy to, is a different matter.
Okay, you find that particular reference in the testimony of Signorelli. I don't specifically recall that at this point. I can review my notes, or you could find that in the transcript.
I'll look for it in the transcript.
Right. And you can do that and bring it to my attention first thing Monday morning as far as the specific references in the transcript of Signorelli's testimony, and if the defense wants to locate that portion that dealt with the admissibility of the Haymans, or reference to the Haymans in Signorelli's testimony, and if there's a difference in the transcript and my recollection of it, I'll certainly be glad to look at it again.
Well, our position would be, Your Honor, no matter what Mrs. Signorelli is saying, okay, that evidence is before our jury, but there is no need for Mr. Whitkin's testimony about how Lyle acted or what Lyle did, that actual testimony, to come in before our jury. As far as our jury knows, Eric was of the impression at some point, and we can prove to the Haymans when, that his brother had erased the computer the day before. That came after Signorelli. It doesn't mean that there's a basis, therefore, for Mr. Whitkin to testify to his conversations with Lyle or what he did.
Okay.
Now, if we were to dispute it in our case, I think that might open the door to Whitkin coming in and saying in rebuttal, but we're not going to dispute that Eric learned when he was there with the Haymans that his brother had erased the computer the day before.
All right, let me have counsel cite us all to the Signorelli testimony that relates to Whitkin. And we will discuss that first thing Monday or whenever it is before Whitkin's testimony, so we can decide whether this should be before both juries or just the Lyle Menendez jury. All right. Any other matters that have to be resolved before Monday's testimony? The first witness Monday will relate to the tape recorded interview of Eric Menendez and then Lyle Menendez on September 17th.
We may not do Lyle Menendez on September 17th, but because you may not have time. But Eric's jury is coming in an hour and a half before Lyle's, and so we want to put on evidence for that jury.
Yeah.
And so we'll have to, maybe we can resolve this issue with the Haymans and Mr. Whitkin, and then then Mr. Hayman can testify during that hour and a half period.
Okay.
Okay, so we're trying to fill up.
What are you going to do when the Lyle Menendez jury comes in? Which witnesses will you have?
Mr. Whitkin, and we're having the coroner and Mary Ellen Mahar, who's a Rolex watch lady.
How long does a coroner's testimony, or how long is it expected to take?
I think it'll take a while, and I'm not sure if it's going to take a whole day or half day. Maybe the defense could give me some clues to how long they think it will take.
We have do we still have unresolved the extent of usable photographs?
Yes, at this point, the photographs that were presented to me for review were related to the testimony of Detective Zoller and only related to the crime scene investigation, and that was why it was marked as exhibits, or why they were marked as exhibits. And if there are other photographs that you are offering, perhaps you could spend some time going through those exhibits and identifying them so that we can have them presented to me before the hearing as well.
The court hasn't ruled yet on the admissibility of all the crime scene photos yet, though.
I mean, every one of them, or just those that have been marked?
Oh, obviously the ones that a whole packet was marked, I understood.
No, well, what happened was that
The ones that just had the evidence, I know that. The ones that just showed bits and pieces of evidence with the little numbers, I know the court ruled on that batch.
Yes.
But I thought the people were also submitting a whole lot more photographs of the decedents.
Yeah, they gave me as I understand it, all the crime scene photographs that were taken. And the purpose of giving them to me was to perfect the record, because when I made my analysis under Section 352 in relationship to the photographs that have already been marked as exhibits, I did have before me all of the crime scene photographs. Ms. Morrissey gave me 2 notebooks of photographs that I looked at. I paid more attention to the photographs of the interior of the house rather than those of the exterior. And also, I had seen most of those photographs before, or many of them before, in reference to let me back up. I've seen some of them before in reference to the grand jury exhibits that I looked at, and I'd also seen many of the coroner's photographs. And what happened was that to perfect the record, the people wanted to present me with all of the crime scene photographs so that the record would indicate which photographs I looked at and which photographs I have permitted to be used. So I don't know if the prosecution is offering more photographs or not.
We're going to be offering certain autopsy photographs, and I think what I'm going to need to do is meet with Mr. Burke We have met, we never finished, but I now have 8x10 blow-ups, and I think perhaps we could do that this afternoon.
That's fun.
All right, now I don't know if you finished with all your crime scene photographs or some of those that I excluded have some relevance to the coroner's testimony. I really don't, that's up to you folks as to how you're presenting your case as to which photographs you're using.
Okay, first of all, I want to clarify for the record that I've submitted to the court rolls 1 through 10, just so that the defense knows, which are only dealing with the crime scene and not the other views of the house, like the kitchen and things like that.
Well, there are exterior photographs as well, I believe.
Okay, well, the intent was just to get the crime scene photographs. I will be offering some, but not all, of the coroner's photographs to describe the nature and location of the wounds. In addition, when Mr. Lenhart, the criminalist who's an expert in the serologist, testifies, there will be 2 to 3 further photographs that he used in his evaluation of reconstructing the crime scene. So I will discuss those with Mr. Burt since I think he's the designee.
Okay. And obviously we should allocate some time before the coroner's testimony to deal with that or before the other expert's testimony.
Yes, I think that perhaps what I could do is, I don't have Dr. Golden coming in until the afternoon, so perhaps I could give those to the court in the morning and then indicate which ones are in dispute, and then the court would have time to look at them, or I could come at 8:30 and do it. Whatever.
No, whenever, if I have it in the morning and the coroner doesn't testify until the afternoon, that's fine. And if the coroner takes a full day's testimony, then you wouldn't expect to get to Dr. Oziel until Tuesday afternoon.
That would be correct, Your Honor. And I'd like, does the defense think it will take a full day for Dr. Oziel?
Yes.
Meet with Dr. Golden.
I'm sorry, Dr. Golden.
I don't think a full day.
I don't think it'll take beyond a full day. I would be surprised.
But you think it might take a full day?
That would be the outside limit.
Okay.
I would expect it would be less.
So it's possible we can get to Dr. Oziel the morning, Tuesday morning or early afternoon. How long do you expect Dr. Oziel's testimony to be?
At least a day.
I think I agree with that.
At least a day, maybe 2.
All right.
We also sort of had hanging evidentiary hearings on the spending, the Hotel Bel Air.
Yeah, you had some witnesses you wanted to bring
I'm
in.
trying to figure out when. One of them's coming in from Florida. I was going to have her come in Tuesday afternoon. If you think Wednesday's better, we'll do Wednesday. She can come in Tuesday and stay through Wednesday.
Okay, well, we'll try to fit that hearing in. It shouldn't take very long.
Do you want to do it Tuesday? Just to have Mr. Goldberg here for sure. It's his schedule that's difficult.
Well, what I don't want to do is interfere with whatever the people's schedule is because they're still putting on their case, and I want to defer to them as far as when they're calling their witnesses.
Wednesday? Just assume we'll have that 402 on Wednesday.
But you could,
No, I think I'd assume we do it Thursday.
yeah, if Dr. Oziel's on for 2 days, then obviously you need, I would prefer to finish his testimony without interruption of other hearings and other matters.
I would like to finish the 2 doctors, if you could, before we do the hearing.
Yeah. All right, anything else now?
We're trying to figure out, Your Honor, when we should have our first witnesses available, and our first witnesses are from out of state. Is it safe to assume Monday, and if people rest earlier, like late Thursday or early Friday, that we're not going to get chastised for not having a witness available first thing Friday?
Is that your expectation that you'd be resting towards the end of next week?
Thursday or Friday, Your Honor, I can't tell right now. I don't know how long these hearings are going to take. We still have a few witnesses at the end to put on, so.
We also need to know how extensively they're going to be permitted to get into the burglaries. The court's ruled that it can come out with Dr. Oziel in a limited method, but whether they're going to call 3 witnesses and go through.
All right, well, we can discuss that now if you like. That's certainly something that should be resolved. And also, yes, we're going to go back to schedule if it works out that the people complete their evidence late next week. Certainly you can have until Monday to start your defense. Regarding the evidence of the Calabasas burglary and grand theft, what is it that the people intended to put on by way of evidence to prove these events occurred?
We intended to put on victims John List and Sharon Ginsburg to establish the corpus delicti, and then to put on Deputy Loftus from the Sheriff's Department to testify that Jose Menendez, in the company of Eric Menendez and his attorney, turned Eric Menendez into the sheriff's authorities, at which point there was a confession. And this occurred about a month after the burglaries occurred, after a pretty lengthy and detailed investigation. So we would intend to put on those witnesses.
And what is the defense
Well, that
response?
doesn't really tell us very much. I assume by saying that the people intend to prove the specific details of all the property that has been removed and all the property which was returned. And as far as Jose Menendez turning the client in, I don't know how they're going to establish that. All they know is that my client, his lawyer, and his father are at the sheriff's station with the property. My client agrees to an interview and conducts an interview. So I don't know, I've never seen any statement, I have the burglary file, that Jose Menendez is turning his son in. Certainly isn't turning his other son in. So we would object to any specific details about these burglaries coming in as being completely irrelevant to the issues for which the people claimed they wanted to use the burglary evidence.
Well, it seems to me that the burglary evidence can be established by stipulation as far as the bare bones of what happened, what was the nature of the incident, the date, time, location,
Right.
perhaps a relationship of the victims to the defendant, and the time of the arrest or date of arrest, and the fact that the father was there at that time. And I don't know what else you need. That's basically all it is, to establish that these events occurred, to deal with the offer of proof of the prosecution and the analysis under Section 352 of the Evidence Code that the court has gone through and has ruled that this evidence is admissible on the theory that it relates to the underlying relationship of the parents to the defendant, and the other references that I've made in my earlier analysis of this subject. I'm not excluding other factors that I've already said I considered, in that I'm just referring to one of those things that the people have argued is a basis for its admission. Right. Yeah, I don't see any reason to have people come in and testify about these things. It's really something that is not in dispute and is something that can be established by stipulation and agreement and put on rather quickly. So I'll let counsel work on that, and if there is some need for the court's assistance, we can discuss it. All right, anything else then other than that?
No.
Any other matters that relate to testimony of any witnesses?
I don't think so.
All right, there are a couple matters I want to discuss with counsel in private, so we'll do that, and we'll conclude these public hearings at this point and be in recess until Monday at 9 o'clock. And when the courtroom is cleared, I'll discuss these matters with counsel.
She started from nothing and really built her way up. There was the glam, there was the beauty, there were the cars, the houses.
Srimati Indranee Mukherjee, the CEO of INX Media.
What has happened to Sheena?
Breaking news just coming in. Media tycoon Indranee Mukherjee has been arrested by the Mumbai police on charges of murdering her sister almost 3 years ago.
It's a case that has confused, fascinated, and shocked us all.
What is the precise motive that could have led Indranee to kill Sheena in cold-blooded murder?
Go on then. Ask me whatever you need to.
Each and every character of this particular story is extremely unique. Everybody has got their individual agendas.
Sheena, who till yesterday we thought was Indranee's sister, has turned out to be her daughter.
स्टार्टिंग में अगर एक झूठ ब्रॉडकास्ट हो जाता है, सबको ये जानना जरूरी है कि पहला सच है क्या।
Peter's son, Indrani's daughter are involved.
The son of the current husband is seeing the daughter of Indrani's previous marriage.
The family themselves, they're leaking a story a minute.
Do I believe someone within the family knows what's happened to Sheena? Absolutely.
Did you murder your daughter, Sheena?
What a stupid question.